You were hired to look into the validity of that statement.
The story, yes, like I said.
However, you don't know whether there was actually a deer on the road that night.
No, I wasn't there.
In fact, you reviewed Taylor Hobson's affidavit in this case.
Yeah, and I was here when he talked.
Exactly, you were here too. He was in the back seat of the car that night.
I think so, yes. He couldn't really see at the front.
Taylor Hobson never saw a deer that night.
Right. He was sitting behind.
You reviewed London Bennett's affidavit in this case.
Yes?
London Bennett lives on Canyon Road.
Yes, that's the eyewitness I was talking about.
London Bennett was the eyewitness. London Bennett never saw a deer on the road that night.
No, just a peach-colored dog.
We also know that Peaches is only about 20 pounds, correct?
Peaches?
Objection.
The dog.
Hearsay.
Your Honor, this is in London Bennett's affidavit. This expert has reviewed London Bennett's affidavit, therefore we can go into it on cross-examination.
May I respond? This witness is not related the size of a dog to any specialized knowledge that he has. So pursuant to Richards v. Mississippi Barbecue, this is still hearsay as he's just being a conduit of this information.
Sustained.
Motion to strike those statements.
No one, other than Danny Dawson, in this case, ever talked about seeing a deer that night.
Not to me, no.
We also know that Danny Dawson was drinking that night.
From what I learned, yes.
You were in court when Pat Lawrence said that Danny Dawson had 11 drinks.
Ordered 11 drinks, nothing about drinking it.
You never looked into the plausibility of Danny Dawson losing control of that car because of alcohol.
Oh, I can't do that. That's not an accident reconstructionist's job.
You were hired to look into what caused the accident, though, correct?
Yes, but I cannot factor that into my equations. Alcohol is beyond my purview. I mean, I had my fair share of vodka, but that's not exactly expertness.
So you did take into account that Danny Dawson was drinking. Doesn't matter how much, but just that he was drinking that night.
She, but I can't. Not that I didn't, I can't.
Now, you said on direct that Danny Dawson went off the road. Danny Dawson caused the rutting that wasn't on the road.
Right, look, the tires on the side of the car.
When Danny Dawson left the road, he was traveling at 51 miles an hour.
Objection. Improper opinion.
Your Honor, this is this expert's testimony. It's in his affidavit. These are the conclusions that this expert came to as to the speed of the car.
May I respond? Pursuant to Rule 702, there must be 3 prongs that are met before any expert can give their conclusion. That they had sufficient facts and data, used reliable principles and methods, and applied those reliably in this case. We have heard none of those things today, and we would be substantially more prejudicial than probative for the jury to hear a conclusion and not know at all how it came about.
Sustained.
Motion to strike that question.
Mr. Roman, you went to school to become an accident reconstructionist.
I went to school for mechanical engineering. I didn't have training, but they are definitely related.
And then you got your certification to become an accident reconstructionist.
Yes, I have lots of certifications. My mother is very proud.
Now, on direct, you testified to all the facts and data that you had in this case.
No, not all of them. There are a lot more than I mentioned.
Leslie, you relied on the Windsor and Strasbourg treatise to come to your conclusions about speed in this case.
Well, yes, I call it an estimation.
And you yourself came to an estimation about Danny Dawson's speed that night.
Yes, I did.
Danny Dawson was traveling at 51 miles an hour.
Improper opinion. May I be heard? We still have not yet heard the reliable principles and methods that this witness used. And we also heard that this is an estimation of the speed that the car was traveling. This isn't a conclusion. Therefore, it would be substantially more prejudicial and probative, once again, for this witness to say this conclusion than for the jury to hear it.
Your Honor, I can show that the Windsor and Strasbourg treatise is a treatise that many accident reconstructionists use in that field. It is very reliable. He had reliable facts and data. Therefore, he is a reliable expert to come to a conclusion about the speed.
Overruled.
Now this treatise, this Windsor and Strasbourg treatise, is a treatise that many accident reconstructionists use in your field, correct?
Yes, all of my Facebook friends I mentioned earlier.
And after using this treatise, you came to the conclusion that Danny Dawson was traveling at 51 miles an hour when he left the road.
Yes, that's my guess based on the math, but I don't really trust what Officer Foster did.
Well, we're not talking about Officer Foster here. We're talking about your conclusions. The speed limit on Canyon Road is 35 miles an hour.
Yes.
So you came to the conclusion that Danny Dawson was traveling 16 miles an hour over the speed limit.
I had a guess, yes.
No further questions.
No redirect, Your Honor.